My name is Tammy Taylor. I am the founder and CEO of Tammy Taylor Nails. On April 2nd, 2024, I filed a lawsuit against Melanie and Pete Fillion seeking $100 million in damages for the damages that they have done to my name and my brand. From 2017 to 2022, I granted the Fillions the limited right to sell Tammy Taylor nail products in Australia and Africa. This was terminated in 2022. From 2018 to 2021, I granted the Fillions the limited right to develop Tammy Taylor salons in Africa. This was terminated in 2021. The Fillions continue to use my name, my copyrights, and my trademarks in social media and advertisements to falsely claim that they are still affiliated with me and Tammy Taylor Nails. They are not.
The Tammy Taylor Saga is back in the news with the founder and CEO Tammy Taylor, based in the USA, stating on social media that SA glam couple Mel and Piet Viljoen are illegally using her trademark in South Africa. So this has left us with quite a few questions, especially given the difference in USA and SA laws. And here to help us understand it a bit better is Nishat Slamdien from Spoor and Fisher. She's an associate at Spoor and Fisher. Nice to have you with us, Nishat. Welcome.
Thanks very much. It's great to be here.
So let's start with this whole scenario that's busy unfolding again on social media. Does South African IP, so intellectual property law, protect international trademarks like Tammy Taylor?
Yes, absolutely. So our Trademarks Act grants protection to international trademarks if they are well known, and if the owner of that trademark can prove that the sector of the public has knowledge of the trademark in South Africa. And the trademark doesn't have to be registered in South Africa. Unregistered trademarks, they are protected under South Africa's common law. However, there is a benefit to actually registering your trademark, because a registered trademark that is actually reflected on our trademarks register constitutes evidence of the owner's right to that trademark. And the owner would have better success in actually enforcing their rights if it's registered.
Okay, and do you know, is the Tammy Taylor trademark actually registered in South Africa?
So anyone can actually conduct a free search on the trademark register to see which trademarks are registered in South Africa, and they can do so by accessing the CIPC website. So CIPC stands for Companies and Intellectual Property Commission. So I did a quick search on the CIPC website, and there are actually a few trademarks that are registered for the words Tammy Taylor. So the words Tammy Taylor in block letters are actually registered according to the CIPC records. And Tammy Taylor Nails is currently the owner for this trademark. Another trademark is also registered, and that is a logo. And a logo is something that's a special font or a picture or a combination of the two. And actually, Just Smart Mobile actually sought registration of this trademark in 2016. And Melanie Viljoen was actually the director of that company. But Just Smart assigned this trademark to Tammy Taylor US. So Tammy Taylor US is actually the owner of that trademark as well.
Ah, I see. Now, so given the allegations of unauthorized use of this Tammy Taylor trademark by the Viljoens, what are the key considerations for determining trademark infringement here in South Africa?
So actually, only the owner of a trademark can enforce the trademark against an infringer. And according to the Trademarks Register, Tammy Taylor US is actually the current owner of the Tammy Taylor trademark in South Africa. So as the registered owner of that mark, Tammy Taylor can take action against any unauthorized use of a trademark that's identical to a trademark or similar to a trademark, and if it's used in relation to the same goods or the same services for which her trademark is registered.
I don't know if you saw, but they actually changed their logo this week. I think it was, in recent days, they actually changed the Tammy Taylor logo here in South Africa. I think it now says Tammy Taylor Beauty or something, which is very, very interesting. So, but Melanie Viljoen claims that you cannot license something that you don't manufacture. Is that correct? If what you are manufacturing has the Tammy Taylor trademark on it?
So that's not entirely correct. The owner of a trademark can grant anyone a license to use the trademark, and most brands actually don't manufacture their own goods in-house, and they enter into various manufacturing agreements with manufacturers to produce their goods, and then they actually then apply that trademark to those goods. The function of a trademark is to indicate that the goods to which a trademark is applied originates from the trademark proprietor. We're not talking about where the goods were manufactured. We're talking about who exercised control over the goods, who exercised control over the quality of the goods, who exercised control over what the goods should look like. And ultimately, that would be the brand owner. Even if the Viljoens obtained the same products from the same manufacturer as Tammy Taylor, they can't label that product with any Tammy Taylor trademark. If they do so, then those goods would be considered counterfeit.
And that's what they're doing. So Melanie also claims that she invented the concept of the Tammy Taylor franchise, that she filed the Tammy Taylor trademark and also built up this Tammy Taylor business here in South Africa. So how does this fit in with what Tammy Taylor herself is now claiming?
So it seems that from the videos that Tammy Taylor has posted to her social media accounts, she's claiming that she granted the Viljoens a limited right to sell Tammy Taylor branded nail products in Africa and also to develop nail salons in Africa for a limited period. We are not sure what agreements that the parties concluded, but it seems that a limited right was granted to the Viljoens. So it's important to note that franchising and trademarks, they go hand in hand. So when you franchise your business, the primary right that a franchisor is actually granting to its franchisees is the right to use a trademark. So the franchisee actually has no ownership to the franchisor's trademark. The franchisee would only be permitted to use the franchise's trademark for the term that the franchisor allows.
Okay, and what remedies does South African law offer for trademark infringement?
So the owner of the trademark can get an interdict to stop any unauthorized use of their trademark. They can also demand the removal of the trademark from any goods and advertising material. They can claim damages. Instead of damages, the owner can also try to claim a reasonable royalty.
Okay. And now the burning question that I've been meaning to ask you all along. Tammy Taylor is asking for $100 million.
Yes.
Will she get it?
So damages is very difficult to prove in South Africa, and damages is based on what the plaintiff can prove in evidence. So it's unlikely that Tammy Taylor will be awarded $100 million. She's more likely to get about maybe 5 to 10% of the annual turnover, but ultimately she has to prove what loss she has suffered in her evidence.
Okay. And I'm just wondering, if there's a court case, who's going where? Does she come to SA or will the Viljoens go to the United States? Or will it be like a video court session? I think that's quite an interesting question.
So if Tammy Taylor actually does institute a case against the Viljoens, it could be that perhaps a written agreement was concluded with the Viljoens, and maybe there was like a clause or a provision in that written agreement where the Viljoens consented to the jurisdiction of the US. That seems to be what Tammy Taylor is alleging. And if that is the case, and she does sue them in the US and a judgment is granted against the Viljoens, Tammy Taylor can then approach a South African court to try and enforce that judgment against the Viljoens.
And what advice would you give to brand owners here in South Africa or entering South Africa regarding managing and protecting their trademarks?
So I would say try to create or select a trademark that is very distinctive. Do a few Google searches to see if the trademark that you want is currently being used or if a similar trademark is currently being used. Also, just try to do a search on the trademarks register to see if a trademark that you want is actually registered. A free search can be conducted on the CIPC's website. If you find that after your searches, your trademark isn't being used or a similar trademark isn't being used, then you should file an application to register that mark immediately. So a trademark does take some time to actually proceed to registration. It takes like approximately 18 months or so, but the rights that you would get would stem from the date that you filed your application. So the sooner you file that trademark, the better.
And just so we don't end up like the Viljoens, what advice would you give to South Africans looking to obtain a franchise or a license to use another person's trademark?
It's really important to do your homework and conduct research on who you're getting into business with. So conduct research on the franchisor, conduct your research on the licensor, and on the trademark that you will be using. So talk to franchisees, get their honest opinion on the experience, talk to other licensees, get your franchise or license agreement in writing. Your agreement should include the amount of money that you are investing. It should include any fees that you are required to pay. It should stipulate your responsibilities clearly. And it should also, very importantly, state what happens if either party cancels the agreement. So these agreements can get pretty complex, and it would be useful to seek out the help of an attorney just to help you understand your rights and your responsibilities. And also, very importantly, if you are disgruntled, don't take things to social media before seeking legal advice. Mm-hmm. Legal advice may seem costly, but ultimately it would be less costly than having to defend a matter in court.
Exactly. Otherwise, it's just back and forth that we're seeing at the moment on social media, and it's not healthy. Yeah, it's like a tennis match, back and forth, back and forth. Nishat Slumdien from Spoor & Fisher, thank you so much for your time today. Spoor & Fisher, of course, well known for its specialist expertise in intellectual property law. We appreciate your time. Thank you so much.
Thank you so much. It was a great pleasure.
You are a leader, a visionary. You embrace technology to develop cutting-edge solutions. You are original and innovative. You imagine. Trailblazing is often a lonely path, but we see the extraordinary in what you do. When it comes to understanding and protecting your intellectual property, your journey is our journey. Visit our website at spoor.com and discover how we can protect what is uniquely yours. Spoor & Fisher. Create it. Own it.